on their face to be captured, please feel free to have your cameras off. Like I am. I'm joking. But thank you, Yuan, for having yours on. Here are the face of today's session. Welcome to Liverpool Advocates of Windrush Q&A monthly session. We will be covering the Windrush schemes, compensation schemes, specifically eligibility criteria. We have had a request to cover the Windrush scheme status eligibility. And given the fact that before you can go on to claim compensation, you need first to rectify your immigration status. We've agreed to look at it, at least for the first hour of this 2-hour session, and see where we get to. For the second hour, we will be covering the compensation scheme as previously advertised. If there are any questions as we go through, I will be sharing my screen so you can see where I'm getting my information from and what I'm reading or what we're discussing. Please feel free to put up your virtual hand or come on the mic if that's not possible and ask your question. Yuan, do you want to add anything? Yuan will be co-hosting with me today. You're on mute, Yuan.
Yes, Tanika, thank you. I wanted to add that I actually don't know what I'm doing. I've never done a Zoom co-hosting before, although I will be giving, I don't want to say presentation, but I'll be giving a speech on my area of expertise, which is immigration and nationality law, with 20 years research in the area, and also covering the changes that have been recently made and announced to the Windrush scheme. We'll be perusing some of that. We won't go in depth because the changes were only made on the 1st of November. We're at the 3rd of November, so I haven't had time to go through all of the changes and compare them to the last version of the document. So that's what I'll be touching on today.
Thank you very much for that, Yuan.
Welcome.
As Yuan has already identified, they're the new modified versions of the schemes. There were 6 parts of the Windrush. A scheme will be sort of loosely used because, for example, you have the Windrush Compensation Scheme, the Windrush Status Rectification, the Windrush Scheme Guidances for claimants. You have the rules. There were 6 different areas that were included, that were updated. And as Ewan said, we have not, or I too have not had the opportunity to go through it. Ewan brought it to my attention yesterday, and it was updated Friday. I was preparing for this session up to Thursday, and it was not there. But we say all that to emphasize the point that updates are assumedly going to be monthly from the last thing I had read. So if you are going to make an application, please do look to ensure that you have the latest version and the time of the month you're hoping to put in said application, because the next day it could change, as in this case, our preparation for today's session. I will be sharing my screen. We will first start with the Windrush Scheme Caseworker Guidance, which deals with status rectification. Why we're looking at the caseworker guidance and not the actual application forms, I personally find that reviewing the caseworker guidance informs better what you can advise applicants to put in an application form. Also, what one of the updates I have noticed is that with the application forms, they now identify which part or section or page in the caseworker guidance the applicants need to confer when they are completing their applications. So for that purpose, I just think it makes sense for us to go directly to the caseworker guidance, which is what the Home Office staff uses to assess an applicant's application. I'm just gonna share my screen. Can you see my screen, Yuan?
I can, yeah. Yes.
Okay, Thank you.
So you want to take it away or you got it?
I could start and then I will ask you to come in.
Let's go on.
Thanks. Hi, Neil. Welcome, everyone. I know Neil, so hence I said hi to him, not saying hi to everyone else. But if you can kindly put in the chat where you're joining us from, that will be brilliant. Thank you. So we are
Oh,
using.
just briefly, sorry, Neil, were you at the conference last week?
You're a mute, Neil.
His face looks familiar.
Yes, he was in one of the pictures that was sent, but
Oh,
we digress. We are now on. Thank you for that, Neil. On version 8 of the scheme, and it was updated. You can see at the bottom here, the 1st of November 2024. And it was published for Home Office staff. Looking at the eligibility criteria, this is a 53-page document. Also, it says here, 1 of 53. How we determine where the eligibility criteria is using, if you were to find this, what I will do actually, or Ewan, can you please post the links to these in the chat? So if people do want to go through it on their own or in their own time, they can. Thank you. So today's purpose, we will be going to page 18. As you can see from the guidance here, page 18 deals with the Windrush scheme groups. Page 18 to page 30 explains what the different groups are. There are 4 groups. Because in the interest of time, however, we will go to page 30 to 35. Sorry, page 35 to 53, which gives you the table version of the same groups. And it helps me explain it better and provides a visual to the audience rather than just streams of pages scrolling through. So page 35, table of the Windrush scheme groups.
Can we start with page 6? I think that's the better page to start where the changes were actually made.
Okay.
So if you want me to lead on this, I can lead.
Okay, go ahead. I know you're, yes, thank you.
So everyone, this document was released on the 1st of November, which is Friday, and these are the changes from the last version. But we haven't been able to compare exactly what has changed with the last version and any versions prior to that. This is part of the complexity that we face when the documents are updated, and there's not a definitive answer as to what changed. So here we can see some of the topics where changes have been made. So in the intention of the Windrush scheme, the documentation scheme, there's changes made there. There's some changes made to the background of the information that they give in this guidance, and also some changes made to the operation of the scheme, the way the scheme is intended to operate, and how the Home Office makes its decisions on the applications that are sent in. So these are some of the areas. There are also the Windrush scheme groups, which is important because your eligibility criteria comes under different groups. And so if there's changes made to any of the groupings, it may include more people who were previously excluded from the scheme. So we're looking at some of those changes. As I said, we didn't have much time to cover it entirely, but we wanted to bring it to everyone's attention. So even if you have an older version or if you've looked at this before and would like to compare it and see how more inclusive it's become, this is where you would want to check these areas. There's also some information on returning resident guidance. We've seen a lot of problems over the past 6 years since the Windrush scandal, where returning residents, particularly from, say, West Africa, parts of Asia, and other parts of the world, are being denied returning residents visas. and the bar seems to be higher for them to prove that they have ties in the UK, family ties and other ties that would come within the remit of what's acceptable to issue a returning residence visa. So we want to have a closer look at that. And also the table of the Windrush groups. The tables expand more on the groups and expands more on the eligibility and gives sort of an example per se of how a person may qualify. So those tables are also very important. And again, it is quite a great deal of information that need to be compared. And we feel that some of these changes may be related to announcements that were made recently by the Home Secretary and the Minister for Migration, and also that some changes may have come about from pressure, be it with threats for judicial review and or new policies that may have come about in recent times. So we want to have a closer look at some of these. I made a small note, Tanika,
Where would you
and
like me to go? Which page?
intention
Okay.
first. Yeah. Um, so it says here on 16th April 2018. I think we know most of this stuff anyway. So I don't want to go through all of it. But
Do you want
um,
me to point at what's important, what we identified yesterday
yeah,
instead?
you have some notes. Let's go through them.
So, what you and I, after we discovered that there were updates yesterday, with the intention, in my opinion, it was made clearer that the scheme, for the first paragraph, for example, that the scheme, what the word means, Windrush, the scheme formalizes and extends the assistance provided by the Windrush Help Team to help the Windrush generation to prove their settled status or right of abode or to apply for British citizenship. The scheme allows those in the UK to remain and those who are overseas to return. The intent is much, much clearer than previous versions. One of the things that the intent makes clear is why is it the Windrush scheme, when we hear about it more often than not, only refers to Commonwealth countries. And when it does refer to Commonwealth countries, it refers to Commonwealth countries, individuals who settled prior to 1973, 1st of January, and then separates that with any other citizen from the rest of the world. One of the questions I've been asking for years, well, isn't a Commonwealth country or citizen of the rest of the world if they were to come after 1973? How does that make sense? Why is it so definitive and distinguishable that the Commonwealth countries' citizens had to have been settled before 1st of January 1973?
And let me give you a brief example of exactly that. So there was a woman from Trinidad who came in February 1973. The cutoff date for this scheme, for the first part of the scheme, 1948 to 73, was the 1st of January 1973. She came in February and she came from Trinidad, which is a Commonwealth country. And the other part of the scheme runs until 1988, from 73 to 88, for a person of any nationality. Is that correct? That's the correct wording, right?
Yes,
And,
highlighted.
and he was completely excluded from the scheme. And so the difficulty was, and the questions put to the Home Office is, isn't Trinidad a Commonwealth country, or isn't she a person of any nationality who arrived between 73 and 88? Why is she excluded from the scheme? And that went on for years until last year, she was finally accepted under the scheme. So just to give a brief example of that,
So,
carry
thank
on.
you for that. And what basically it says now, if you go to the background, it says the Windrush generation are people, very first sentence here, who came before 1st of January 1973. And if they were one automatically settled or given right of abode, under the Immigration Act here. However, people from other countries other than the 65 Commonwealth countries for the purpose of this scheme, bearing in mind there's 56 Commonwealth countries, but the 9 that makes it 65 that's listed are countries that are either British dependencies or territories. Nonetheless, one of the things that they've done here is identify the term Windrush as being the Empire Windrush, and it was Dr. Tilbury, 1948. One of the things that still failed to do, in my opinion, is they've listed who the ship brought. It brought Jamaican, Trinidad and Tobago, and other islands citizens as a response to post-World War labor shortages, not any Europeans or anyone else, which we knew were on board. Again, the other countries that came between 1973 and 1988, that was a period when the UK joined the European Union. Ewan can speak a bit more on that, but Ewan, you're doing this section, so I'll let you take it from there.
So one of the things that we noticed, and I gave a presentation on this just recently, I won't expand on it too much, but on the very same day in January 1973, when the Immigration Act came into force and took away the right of abode, the right to live and work in this country from 4.4 million citizens of British colonies, it then, on that very same day, the 1st of January 1973, Britain's membership of the EU came into force, paving the way for 400 million Europeans, non-British nationals, to get exactly those same rights to live and work in the United Kingdom. So I think that's very important, but it's a matter that's not discussed or widely known what actually happened on that day. The actual intent of taking away the rights of citizens, and it's a policy that operates basically on the color of your skin, because what you find in the 20 remaining British colonies at that time was that it was predominantly Black and brown people. I think the only predominantly white colonies at that time was Gibraltar and the Falkland Islands. So we're talking about Hong Kong, the 14 remaining territories, Grenada, St. Kitts, Antigua, Belize, and maybe one other country. So I think that's important for us to remember, that sticking point, that people attached to those countries had their rights taken away and they were given to European nationals. So it was never about the numbers, because 4.4 million is only 10% of the 400 million that they gave those rights to.
Thank you for sharing that, Ewan, and why that's important. The Commonwealth citizen meaning here in the caseworker guidance states Commonwealth citizens means citizens of these are the countries. If you look at the list, which I have, none of these countries are European territories, countries. None are. However, if you look at the Home Office fact sheet, the most successful claimants to the Windrush scheme, the status rectification, are European citizens. Then it begs the question, why are those countries not listed here? But nonetheless, these are the countries, for Commonwealth purposes, as per the scheme, that can claim. I move swiftly on to operations. Ewan, do you want to speak on this section?
Yes, briefly, because I'm getting some messages. Is there difficulties with people getting in?
Not that I'm aware of. I don't know. Maybe someone can say if they had difficulty in the chat.
No. We've got about 12 people in now, so is there anyone else?
No, I didn't have difficulty getting in. I got in straight away.
Okay, great.
Thank you.
Great. So I haven't had a chance to really compare this to the last version, but there is obviously something that's changed here in the operation of the scheme. I may have went through it last night. I didn't get a chance to take notes. and compare it to the last version. So I won't expand on this unless you have something to add. I will save this for another meeting.
Yes.
I
But
don't think. Yeah.
one of the things I would like to point at you, and you and I are both supporting people in their own capacities, and many people on the call are too. Why is it that we now have to take time to try to identify what exactly has been changed? Why
Yeah.
can't this be made clear and simple so that we who are supporting others can do so and say, well, okay, for example, evidence, if you're going to make an application, these are now the acceptable evidence. They've widened it to include passports or national insurance number, for example. Just an example. Instead of us now having to go and compare two lengthy documents and trying to find, for want of a better phraseology, a needle in a haystack. Anyway,
Yeah.
that's just
I
me.
agree. I guess that's part of the operational procedure that needs to change. They need to make this more clearer, a juxtaposition or contrast of what's changed and how it impacts.
Agreed.
May be a good idea. Okay, so
Do
what
you
was
want
the
to
other section we were going to?
decide on the Windrush scheme applications? So one of the things I think, in the interest of time, we're now at 21 minutes after, is going to the tables. The tables will take a very long time to go through, and I would like, for the benefit of the audience, to actually go through that. These are the Windrush groups.
Right. So the first group here under the Windrush scheme are those who automatically qualify as British citizens. And one of the problems I saw, and I think it was in, I think it may have been in deciding on the application schemes or one of the other topics above. I know you wanted to jump to this section. One of the notable things I saw was that fingerprints and photograph were a requirement for persons under the Windrush scheme. The problem I had with that since day one, since 6 years ago, my grandfather is an automatic citizen all the way through his life, never lost any citizenship status. And what they had proposed for him as sort of a blanket policy they were proposing for everybody is that they do biometric. And one of the things you can't do is you can't then say that he's a British citizen already automatically and that you're going to conform him to submitting to giving his fingerprints. You can't do that to a British citizen. No British citizen gives their fingerprint to go and get a passport. And that is one of the problems I see in the scheme. I can't remember which section it's under, but it's
Okay.
there as a brick wall. And it then says that if you're a British citizen, but you may have been locked out the country and you may have had a conviction somewhere or something applies, something sort of suspect comes up, then you're prevented from having your status properly acknowledged and recognized, which doesn't happen to any British citizen. Okay. The only thing we've really seen happen to British citizens, I'll give Shamima Begum as an example, is if you're involved in serious acts of terrorism or anything seriously prejudicial to the interests of the UK, then your citizenship comes into question for deprivation purposes to be deprived of it. So I can't understand why, if a person is British, automatically, why they are being subject to giving their fingerprints as a prerequisite to getting that status rectified. I think that's unfair. And I think that's one of the things that we need to ask the Home Office to remove. It shouldn't apply to everybody. It may apply to people who have a lower immigration status, let's say indefinite leave to remain, perhaps. And even then, if those, if any question of criminality comes up, they should be considered, because what you may find is some people somehow became involved in criminality as a result of SUS laws or other circumstances where they couldn't prove their status, where they couldn't survive properly, and things like that. So if there's an issue where their status or lack of status caused that, then that should be overlooked. But for persons who are British citizens and who have the right of abode, they should not be subject to fingerprints.
Thank you very much for that, Ewan. Going to the table of Windrush scheme groups, this has been one of the updates. Yesterday, when Ewan and I were reviewing this, when I reviewed it, it seemed a bit more comprehensive and seemed
Sorry,
go ahead,
Tanika.
Herman. Go ahead.
Neil's just posed a question in the chat. Just as a question he's posed, can that be looked at just quickly?
Sure.
Are all British citizens equal? I.e., oh, okay. We were actually going to get to that.
That was one of the things that came up yesterday, and it was painful to say the least, at least for myself, because nationality law is not one of my areas of strength. However, having a discussion with you and yesterday, I am much more confident in my interpretation of reading the schemes and answering a question like that. So if you can hold on for us, Neil, that's one of the reasons why we've included the status rectification scheme as part of today's session for that one of the same reason.
Okay. Don't forget Anthony Brown. Anthony Brown's got his hand up. Maybe you want to answer that question later or whatever. I'm not sure.
Okay. Sorry, I didn't see his hand. Anthony?
Yeah. I was just going to try to answer a question that was asked, because I think it was said that we weren't sure why the 1st of January 1973 was such a major point for Commonwealth citizens in terms of meeting the criteria to be Windrush.
Oh, yeah.
So that's because that's when the 1971 Immigration Act came into force. So that placed all sorts of restrictions on people and placed all kinds of requirements on people in terms of length of time they had to reside here, and giving them status indefinite leave to remain. So they didn't have all those restrictions on people from the Commonwealth before, but in 1971 that is the cut-off point. So in law, they're always referring back to that point. And so it comes up time and time again in terms of status questions. But the other thing is that it didn't apply to all the people from the Commonwealth. It only applied to those people who had got independence. So those islands like St. Kitts, who didn't get their independence until 1983, it didn't apply to petitions in 1971. The Immigration Act didn't apply to them. It only applied to people who had got independence, because when their independence acts were passed in Parliament, it took away their citizenship of the United Kingdom colonies and made them citizens of Trinidad or citizens of Barbados or citizens of Jamaica. And because you are now a foreign citizen, immigration law applied to you. You are no longer a citizen of the United Kingdom colonies. So that's the distinction that act created on the 1st of January 1971.
Thank you. Thank you, Anthony, for that point. What Anthony was alluding to was the distinction between persons who were previously citizens of the UK and colonies and had more rights of entry and stay in the UK, but then after their countries became independent, they lost their CUKC. And I'm going to touch on that later, because there is a caveat where some people retained right of abode, and I'm going to go through those very soon, very quickly. Let's carry on.
Thanks, Yuan. So I kept the page as it is, so if anybody wanted to read the preliminary to the discussion on the table to follow. And just for the benefit of those who are unable to, the table, which it shows who is not included shows why not and what the Windrush Help team can do to advise people of that. And each table also shows who's included, shows why that might be and what documents they may need in order to be eligible. For the purposes of the below tables, settled before 1st of January 1973 means a person who was ordinarily resident and not subject to any restriction on the period for which they could remain. Those who are covered by the Windrush Scheme guidance tables for Group 1. One of the things we found out of the 4 groups, Group 1 deals primarily with Commonwealth citizens who were here prior, as it says before, 1st of January 1973, or who have the right of abode. Hopefully this may answer Neil's question as we go through it. If you were here before 1973, you are a CUKC, not a Commonwealth nation who had, or former CUKC who had now gained their independence. You may have had automatic right of abode or you were automatically British. Who does this include? You, and do you want me to go through the first column? Or you go?
Okay, go on.
There. Okay, so pre-1973, as Anthony also just provided, thank you for that, Anthony, arrived, pre-1973 arrival Commonwealth citizens in the UK who have been continuously resident since that time. That means if you came before 1973 or your parents and they had continuously resided in the UK till 2024, this could include but is not limited to citizens of the UK and colonies who are still British, nationals of countries which are independent, where independence came in 1981. You and I think you gave me an example of said country which gained independence in 1981.
Antigua and Barbuda, 1st of
Thank
November.
you. Thank you. And lastly, for this first column, British citizens by virtue of the 2002 Act and who did not realize the impact of the residence in the UK.
Nationality and Immigration, Nationality, Immigration and Asylum Act, 2002.
Thank you. The criteria for those individuals who were here before 1973 and has been continuously resident is that they're already British but might not know this.
And I have, so I wanted to look at where it says continuously resident. And I think we need to pick that apart. But it requires more because if there's circumstances where a person did not have to be continuously resident. So example, the 2-year rule would not apply to CUKCs.
We can contrast it with the other group because that's why I made a point of saying earlier, Group 1 only deals with Commonwealth citizens. The other groups deals with citizens who were from any other nationality. And
wait, I'm going to stop you right there because that is the problem I always mention. So on that same first column, citizens of the UK and colonies, right? So Commonwealth citizens is a wider encompassing group, but there are citizens of the UK and colonies in there who had more rights than a typical Commonwealth citizen, i.e., let's say a Jamaican after independence. They no longer had citizenship of the UK and colonies, but they're considered a Commonwealth citizen. And so are CUKCs, but they have citizenship of this country. So it's a broad encompassing term and it's a little bit confusing here. So there's things that we'll pick apart perhaps at another time.
Thank you for that. What they will be eligible for if they meet the criteria. First bullet point, Windrush Help Team assistance to confirm status. Windrush Help Team to signpost and advise on how to apply for a British passport. Where a person does not wish to apply for a British passport, a certificate of entitlement to right of abode vignette can be placed in another national passport. Where a person does not hold a valid foreign national passport, a nationality status document can be issued. This is not accepted for compliant environment complaint, but may be used to enable a UK passport application at own cost. Okay, I'm not sure I understood that, but okay. Moving swiftly on to the next section. Those in the UK who wish to apply for British citizenship. Pre-1973 arrival Commonwealth citizens in the UK. Those who were subject to immigration control, who are in the UK and want to apply for British citizenship. Pre-1973 arrival Commonwealth citizens in the UK. Those with right of abode who are not automatically British, who are in the UK and want to apply for British citizenship. Pre-1973 arrival Commonwealth citizens in the UK. Those who were subject to immigration control, who are in the UK and want to apply for British citizenship. So those are the 4 options or categories of who those in the UK who wish to apply for British citizenship that the scheme provides for. The first criteria, if you are in the UK and you came before 1973, you were subject to immigration control, but now you want to apply for British citizenship. It states that you fall within Section 1(2) of the Immigration Act 1971, which covers those who are subject to immigration control, have been continuously resident since their arrival, where a 2-year break is permitted without disrupting continuous residence, are subject to the usual good character requirement and all naturalization criteria. So we're going to take each of those 3 bullet points in turn. Yuan? Or you want me to do it?
No, go ahead. I'm just catching up on some of the questions quickly in the chat because I'm gonna go back to that. But I think there's also a degree of complexity here. I think you may acknowledge this. So we're talking about people here who are subject to immigration control, some who had ILR, but also you got people who were freely landed or considered freely landed because they came before a specific date. And those are the ones who have no time limit, which on the surface appears equal to right of abode. So for the rest of their lives, they have no time limit for which they can remain in the UK. And I feel it's a higher status than just indefinite leave to remain, where indefinite leave to remain can be called into question and taken away. But again, we don't know all of what's changed here in these tables, so we have to compare them. But what is the point that you see here that's significant, Tanika?
The middle point. I don't know enough about the Immigration Act, Section 1(2), and I was searching that at the moment as we speak. But
yeah, Section 1 just defines the people who are subject to control, who don't have the right of abode. I think. I think. I'm not 100% sure. I'd have to.
So it says Section 1(2) of the Immigration Act 1971 states that people who do not have the right of abode in the UK can live, work, and settle in the country with permission.
Right, that's it.
They are subject to regulations and controls set out in the Act for their entire stay, for the entry, stay, and departure. So that, unfortunately, as it says there in the first column, is subject to immigration control. Right. So it falls within Section 1(2) of the Act.
Right, and we're going to look at a document that was sent to me recently that shows, although some Commonwealth citizens were subject to control, there were special rules for them that would exempt them from new rules that could affect their stay in the UK. So when the Immigration Act was coming into force, we're going to look at Section 1.5 in greater detail because we have another document that sheds some light on it. Okay.
The reason why bullet point 2 it was that stood out to me when we read it earlier was the 2-year rule. The break is permitted,
Exactly.
and we know it particularly as the 2-year rule. If you leave the UK for more than 2 years, then you would have lost your status. In this case, right? I'm
We
too
would
sure.
have lost your ILR would have lapsed, but we also believe that there were some people that were exempt from this because of Section 1, subsection 5. So we're going to look at that as well.
Yes. And one of the things that I think people need to be mindful of is the good character. What is the good character requirement? Good character requirement lends itself to the immigration rules. And good character is to say that you do not have, for example, a criminal record, or you were convicted of such a serious crime that you may be a threat to public, as you mentioned earlier, using Shamima Begum as an example, because her status, even though she was born here, she was stripped of her British nationality because of terrorism. That's as much as I know about it. So if anyone knows more, please feel free to share. But nonetheless,
Links to terrorism. Yeah.
or linked to terrorism, my apologies.
Reported links, yeah.
But nonetheless, in my experience, where it comes to Windrush cases and a good character consideration for status rectification, which then leads to application of naturalization and British passport, they look at one, whether you've committed a serious crime, whether you've been incarcerated, and for how long, what was that crime? Is it conducive to the public good or not? Do we want to give you British nationality and you've committed a crime 20 years ago, 40 years ago? I've had clients who's committed crimes in their teen years or more formative years. And today, in their adult years or later age, they can't get British nationality. Is that double jeopardy, as the Americans will say? Even though there's clear evidence that they've changed their lives,
I think Anthony has a question.
moved away from crime, but that is still a standard and a test that's applied. Anthony?
Yeah, it's just to try and answer some of those questions and to sort of explain another criteria that they set down within the Windrush scheme. So in the Windrush scheme, they say that people from the Commonwealth or any nationality that have come to the UK before the 31st of December 1988, you can apply through the Windrush scheme. The reason for that date is that the 1981 British Nationality Act came into force on 1st of January 1983, and it gave 5 years for people to register or naturalize. So you may have been living in the country as a citizen of the United Kingdom and colonies, and then your island became independent, but you were still living here and never left. Up until 1981, there was nothing that said that you had to do anything. But when the British Nationality Act came in, it said that you had to register. And that's why there was a big scurry. You listen to the stories of our parents, they'll tell you that in the early 1980s, everybody was rushing around getting people to complete their nationality applications because they could just simply register as a British citizen. But then that would expire within 5 years, and so that's why that date is there, because that's when you weren't able to register anymore, and so that's the cut-off point there, and so people who came after that point have a different legal status. So earlier I talked about the legal status that they had before 1st of January 1973, and now there's another status before the 31st of December 1988. Now, within the British Nationality Act, it sets out under what's called Schedule 1 a list of criteria, one of which is good character. So it says you have to have good character. Now, the Act itself doesn't say what good character is. It leaves it up to the Home Office. And the Home Office then comes up with, if you've been in prison for 1 year, then they're not going to give you citizenship until a certain time has elapsed. If you've been in prison for under 4 years, I think you have to wait up to 15 years before they'll give you citizenship back, and then even longer. And there is the Rehabilitation of Offenders Act that doesn't take into consideration offences after 6 years, for work and so on. But the Home Office is not subject to the Rehabilitation of Offenders Act. So they can go back 40 years, and this is why, your client, Tanika, could still have his citizenship refused, even though his offence occurred many, many years before, because the Home Office is not subject to the Rehabilitation of Offenders Act. Also, within that Schedule 1 criteria that says you must have good character, it says that you must have sufficient knowledge of English, Welsh, and Scottish. So that's where the language test came in. You must have sufficient knowledge about life in the United Kingdom. So that's where people have to take this Life in the United Kingdom test.
Some countries are exempt from it, just to note.
Sorry?
No, it's changed now, Anthony. That's why I'm highlighting no requirement for it to do the call now.
Some countries are exempt, but they're exempting it here as well.
So hang on a minute. Remember what I said. This is Schedule 1 of the British Nationality Act. That's the criteria. Now, with Windrush, what the government did was disapply some of this criteria, so they didn't have to then have the language test, because it would be an insult. Asking people who had been colonized for 300 years, do you speak English? So they waived that. They also waived tests, because many people have been living here all their lives. So they waived the test about life in the UK. So, but that's just for Windrush people. Other people still have to do these tests for naturalization.
Thank you for that contribution, Anthony. I would like to speak with you offline, because you said something really interesting from a legal perspective. So I am now a barrister, unregistered. I am really keen on learning, and I'm interested in the law. So you said that the Home Office the Home Office does not have to follow the Immigration Act under Schedule 1.
No, they don't have to follow the Rehabilitation of Offenders Act, 1971. The Rehabilitation of Offenders Act. They don't have to. That doesn't apply to them. But
okay, so who does it apply to, Anthony?
But a good character test, the law itself doesn't set out what good character is. The Home Office decides what how long you're not going to get your citizenship back, depending on what sentence you've had, and so they determine what good character is.
Okay, thank you for that. I will speak with you offline.
Okay.
You were going to say something?
I was just going to say briefly that some countries are exempt from the knowledge of life in the UK test. It also came up years ago as an insult. And some of the Caribbean nations, for instance, where English is their first and only language, don't have to conform to that test.
And there are other requirements as well. Intention to live in the UK. So again, it's if you know you can your principal home needs to be in the UK. Also, that there's certain periods that you might have been outside the UK, so you'll notice on the status forms that you have to complete, they ask you have you been outside the UK 450 days or 90 days and so on, and it's all coming from Schedule 1. So if you look at Schedule 1 of the British Nationality Act, it'll give you all the different criteria that are going to apply to you, apply to people if they're trying to register as a British citizen.
Okay, thank you very much for that, Anthony. We're now at section 2 of the part of the guide, or group 1, which those in the UK who wish to apply for British citizenship. Second part is arrived before 1973 in the UK. You had automatic right. You had rights of abode, but you're not automatically British, and you wish to apply for British citizenship. Yuan, I think this may help, or this will answer some of the questions Neil asked earlier.
Yeah,
So,
I actually wanted to go through the document that we went through earlier and explain how right of abode works, rather
okay,
than
I'll bring it
here,
up.
it's a bit more sketchy.
Okay, I'll attempt to bring it up.
Yeah, I can go through that as fast as I can. I don't know if everybody will get it. I'll try to be succinct and as clear as possible.
Okay, hold on.
And this is Reginald's, he wants to ask a question on it as well.
Okay, I will.
Do you want me to send you a link? Or
do you want to share your screen? It'll probably be easier if you share your screen with that.
Okay, I can try.
Yeah, the last one that you sent us, which was clearer.
Let's try. Bear with me. Share. I don't know what I'm doing here, but yeah, okay, I got it. Okay, so here we go. This section.
Can you enlarge you in, please?
Yeah, bear with me. I'm trying to get all this stuff out of my way. Is that better?
Yes, thank you.
Right. So this chart on the government website defines who has the right of abode in the United Kingdom and how they have it, and also compared to how they had it before 1983. So there's a position under the 1971 Act, and there's a position under the 1981 Act. And so that 81 Act came into force in 83, so that's why it says after 83. And the first paragraph says a citizen of the United Kingdom and colonies who was born, adopted, naturalized, or registered in the UK or any of the islands around the UK has a right of abode under Section 2, subsection 1A of the Immigration Act. The second paragraph defines a child of the person above, and that is a CUKC born to or adopted by a parent who at the time of the person's birth or adoption had that right of abode under Section 21A above of the 71 Act. They would have held this under Section 21B1 as a descendant. And the third paragraph, which is the grandchild of the person all the way at the top, and the child of the person, the second paragraph, a TUKC born to or adopted by a parent who, at the time of the person's birth, had a right of abode under 21B1 above. So this person has it under 21B2. The fourth paragraph defines a person who was a CUKC, a citizen of the UK and colonies, but came from a British colony. So they weren't born in the UK, they weren't naturalized or registered here, but they were born naturally in a British overseas territory at that time. So a CUKC who was ordinarily resident in the UK for a continuous period of 5 years before the 31st of December 1982, any time spent subject to immigration conditions can be included, but the conditions must have been removed before the completion of 5 years. They hold that right of abode under 21C. I'm going to break this all down in a minute. Then there is people who weren't CUKCs, but they also have right of abode. So a Commonwealth citizen, not a CUKC, with a parent or adoptive parent who, at the time of the person's birth or adoption, was a CUKC by birth in the United Kingdom. So this person is a Commonwealth citizen. They weren't born in the UK. They could have been born in, let's say, Australia, South Africa. Their mother could have been born in the UK, couldn't transmit citizenship because there was a gender discrimination. And so that child has, let's say, Australian citizenship or Jamaican citizenship after 62, but the mother is born in the United Kingdom. Initially, I called it the white clause because what you would find in that time was a lot of people this would have applied to were people who were pre-Windrush, people who were born here. The period after following 73 may have included some Caribbean people who were born here, but not in a great way as it would impact other indigenous Europeans or Brits, let's say. Now, the paragraph below, a female Commonwealth citizen who is or has been married to a man with right of abode at any time before 1982. So it's a female Commonwealth citizen who could have been married to a man who simply just had right of abode or who was a CUKC connected to Britain. And that woman would have automatically acquired for the rest of her life a right to live and work here in the UK free of immigration control. Okay? And that also is a gender discrimination because a man who married a female Brit could never acquire this, but a female who married a male Brit can acquire this. So there was a gender disparity there. In the last paragraph, a CUKC woman who is or has been married to a man with right of abode at any time before the 31st of December 1982. So very similar to the paragraph above. The only difference is one is simply just a Commonwealth woman and the other is a CUKC woman who may have come from a colony but didn't actually have the right of abode, but married a British man and got that right of abode immediately on marriage. And right there, I show that there's a difference in the term Commonwealth citizen. So it also means the CUKC woman is a Commonwealth citizen and a person, let's say from Jamaica, who was no longer CUKC at that time. And what this chart shows under the 71 Act is that there were varying degrees of how a person held right of abode, from 21A all the way down to 22. After 83, on the other side, most of those were upgraded, so you didn't have these confusing categories. You only had 21A on that side and 21B. And this is important because a person who has right of abode under 21A is equal to having their citizenship as being born, registered, adopted, or naturalized in the UK. And they can transmit that automatically to a child born outside the UK.
Yuan, can I ask you to briefly, before you continue, explain for everyone again what ROA means?
The right of abode.
Yes, as you use it, as you explain.
The right of abode is a right to live and work in the UK free of immigration control. It is, when compared to British citizenship, it gives you the same exact rights. It is almost it is equal to British citizenship, let me say that. The only difference is because some countries around the world do not allow for dual nationality. So let's say you're Malaysian, I think that country doesn't allow dual nationality, and your parents were from the UK and from the UK, then you can have the rights of a UK citizen without having the citizenship. That is probably the easiest way to explain it.
Okay,
so going back
just a quick one. Reginald's got his hand up. Yeah.
Sure.
We've spent an hour now, 1 hour. But Reginald's got his hand up for a little while. If someone could look at that, please.
Okay.
Okay. Ewan, can you quickly summarize this section here? And then we can go to
So-
Reginald
so
and
just-
we'll ask the
Yeah,
question.
just quick. The comparison I was making is that a person can hold citizenship in two ways, by descent and otherwise than by descent. It's somewhat confusing, but the person who has it by descent was born outside the United Kingdom to a full British citizen. And that person born outside the UK cannot transmit that citizenship again automatically, but they can register their child. And a person who has it otherwise than by descent, which is the highest category, can transmit that citizenship to a child born outside the UK. That's the easiest way to explain it. So in effect, there's almost two classes of citizenship running at the same time with two different sets of rights. Just quickly before I bring in Reginald, if we go back to the chart and you look at the first paragraph,
Richard Black just asked a really good question just on what you were just saying. What's the difference between settled status and right of abode?
Right. So right of abode is also classified as a form of settled status. The no time limit is also considered a form of settled status, and and ILR is considered a form of settled status as well. The difference is the no time limit and right of abode. Right of abode is defined here under, can you bring that back up? Where did it go? Right of abode, did you share back your screen, Tanika?
Yes, can you not see my screen?
Yeah. Okay, so right of abode is defined under Section 2 of the Immigration Act. It's a statutory position, and no time limit usually applies or refers to the right of abode which existed before the Immigration Act. So that right goes back hundreds of years, and it was not as restrictive in its definition as the 71 Act defined it. So they're actually the same things, the no time limit in that regard. So if you came in 1960, Richard, for instance, and you were considered freely landed in the United Kingdom, you have a continuing effective right of abode all the way through. And that is something we have to look at as well. But
okay. So UN, just two things on the chart. One, does somebody asks, does settled status override right of abode? And two, Glenda would like you to repeat, Glenda, I presume. I would like you to repeat what you just said.
Which part?
Glenda could confirm that, but just to answer the question, does settled...
What you just summarized, basically the last few, if you can.
The last part regarding NTL?
Yeah.
Okay. So
for us lay ones.
Yeah. So NTL again is a broad category. It's kind of broad. It encompasses certain things.
NTL means no time limit.
No time limit on your stay in the United Kingdom. So right of abode actually carries that. You have no time limit on the amount of time you can stay here, and you have it for the rest of your life. And that's defined under Section 2 of the Immigration Act. So as I said, it's more rigid. It's more rigidly defined. But the position going back before 1962, the common law right of abode was more loosely defined, where all British subjects had that right to enter and stay as long as they like in the United Kingdom. So the Home Office recognizes a position called freely landed up until a certain point, and even that's still a bit loose. So if you were freely landed in the UK for a specific date, you are considered as having no time limit on how long you can stay here. Still all a bit confusing, but it depends on the dates, and it operates in varying degrees. I hope that helps. Was there something else? Another question, Reginald? or did he want to come in? Can we let him in? Can you unmute Reginald and then ask your question briefly?
Anthony, is that a legacy hand?
No, I'll wait till the others have asked their questions and then.
Reginald, are you there?
In person.
Okay, so
Can you hear me now?
yes, we can. Yes.
Right. Okay. So my question is, what I posted on the chat as well is, how is it that a child of a Commonwealth citizen with the right of abode who was settled in the United Kingdom before 1973 is not qualified for the scheme? And I'll tell you my reasons why it's qualified for the scheme and why I think the Home Office is wrong. In their decision to me when I made my application as a primary claimant, right? They said to me, you were born in Nigeria on the 3rd of January 1978, and you've declared on your primary claim that you first arrived in the United Kingdom on the 20th of September 2006, age 28. An eligibility requirement of a child of a Commonwealth citizen is that you were under the age of 18 when you first arrived in the United Kingdom, but that's wrong. The reason why it's wrong is because my father was not only just a Commonwealth citizen, he was a Commonwealth citizen with a CUKC status with the right of abode.
Right.
Now, even though my dad renounced his citizenship to take up a Nigerian citizenship, obviously because of this hostile environment, he couldn't get a job, he was stressed off, so many things. The law still protects him. And I'll quote where the law protects him. 1971 Immigration Act. Through the existing act as then in force, with the respect to the right of abode in the deceased case, a CUKC who renounced that status in order to retain or acquire citizenship of another Commonwealth country have a residual claim under Section 21B of the 1971 Act. So when you look at it, my dad was first a CUKC under Section 21A, but because he renounced, his right of abode was protected under Section 21B, right? 1971. And those under 1971 who had the protected right of abode in 1981 became Section 21A.
Yes, correct. They were upgraded. When you look at the charts that they did.
Yeah, exactly. So how can the Windrush team say I'm not eligible because I'm a child of a Commonwealth citizen who came to the UK after the age of 18? How is there a barrier on age? There's no barrier on age if you're registered or your parent is registered under 21A. There's no barrier for age. You don't have to come to the country.
I am fully inclined to agree with you. I agree with you in your entirety. And according to Franzman's nationality law, and I think we had an opinion on this before, there were CUKCs who lost their citizenship on independence and some who renounced, but continued to have the right of abode up until 83 when it was extinguished. And so you've already mentioned that there was a caveat that says they continue to keep it in certain circumstances if they acquired citizenship of another Commonwealth country. And then the 21B was upgraded to 21A. I think you were referring to your sibling who was born after 83, who would then also be a British citizen because her father was, right?
Yes.
That's what you're referring to. And
but I'm referring to two aspects of it. The two aspects of it is I was born before 1973. So I am a CUKC, right? With the right of abode, because obviously my dad could pass that status, right? So what the Home Office, outside the country. But I think the Home Office look at it from the point of view that, okay, my dad renounced his citizenship in 1975, but they have forgotten that the 1971 Immigration Act protects the right of abode of a CUKC who renounced that citizenship in order to acquire the citizenship of another Commonwealth country, which he did. he renounced the CUKC to acquire Nigerian citizenship, which was a Commonwealth country and had never stopped being a Commonwealth country. The Home Office has forgotten that completely. So they've treated me as a child of a Commonwealth country without the right of abode. And therefore, I do not qualify for the scheme.
Yeah, and I'm going to show you just briefly what their intention is. So here, when we look at Commonwealth citizens, I'm just going to go back to this quickly. When we look at the Commonwealth citizens, not a CUKC, with a parent or an adoptive parent at the time of the person's birth, who was born, whose parent was birthed in the UK. So the caveat here is there's a benefit down here that sort of derives from up here, where birth is equal to naturalization, adoption, and registration. But down here, that Commonwealth citizen, which would be you in certain circumstances, is only looked at in the context of was the parent born in the UK. And that's why I call it the white people clause. You see where I'm coming from? Because there was, at that time, your father was born in Nigeria and migrated here. It's unfair, is what I'm driving at. It's an unfair position, an unfair advantage. We'll look at your case closer, but we'll move on for now. We will look at it closer, and you've made some very strong points. All right?
Thank you. Thank you.
You're welcome.
Thank you for that, Reginald.
You're welcome.
Anthony, you have your hand up?
Yeah, I just wanted to finish off this section with my contributions to this section by saying that, you know, we've talked about status being removed, we talked about you know, the new acts coming into force, but we've not mentioned that the Windrush scandal was caused because 2014 Immigration Act came in that then required documents that they hadn't given us in 1971 when these acts were passed. Now, they apologized for that and said that they would give us back our status and pay us compensation. But as you can hear, there are lots and lots of problems because the laws that they put in place, they haven't they've changed a couple of things in the Schedule 1 to say you don't need to take the English language test anymore, and you don't need to take the Life in the UK test. But what we're saying is things like the 5-year rule, you have to be back in the country 5 years before you can apply. All of that, now they're saying, you know, by discretion, they can ignore that. But we should be campaigning, or we should be saying that that needs to be disapplied by statute, so there needs to be a law, because we don't know when Suella Braverman is going to come back into office and say, you know, we can't do all this anymore. So what I'm saying is that as well as raising all these issues, we should be saying to them, you know, what about changing the law so that we can get back our status en masse for those who are living in the country, rather than just be all running around in circles trying to chase these documents and have these arguments with the Home Office, you know, at the end of the day.
I agree, Anthony, and I raised that with the minister last week. I told her plainly that these laws need to be repealed because we're swimming through the sludge, the toxic sludge of what these legislations are and what they've caused. And we have a report that says that these laws were built on racist ideology. So why are the schemes as a result are also built on that racist ideology? And we're having to do the same thing over and over. And as someone said to me quite poignantly this week, the only thing that's changed is the way that they say no when they deny you. They say it a bit more politely. That's all that they're doing. So I agree.
Thank you for your contributions, both Anthony, you and there. The next section we'll move swiftly on because we're now 4:15, and I would like us to still touch on the compensation eligibility. Appreciatively, as we knew from the beginning, we would not have been able to go through the status rectification section because there's a lot to it.
Nika,
yes.
before you go, I just need 1 minute. Just 1 minute before you go on to that. I'm going to grab the screen from you. and there's something I need to share. Just bear with me 1 second. Gosh, see if I can find it with all this.
My intention is, Ewan, to still go through the
Here it is.
rectification scheme, but just to highlight the headings to people in case it applies to them, that they can go and look at it in their own time. But go ahead.
Well, we will try and share this document as well. We'll pass it around. But this document from the UK Visas and Immigration, dated April 2014, sets out a position with regards to persons settled in the UK prior to 1973 and their exemption from immigration control, etc., and how the 2-year rule did not necessarily apply to them. Now, this, I want to share it, but I just wanted to mention it because they mention here an exception to the returning residence rule is provided in Section 1, subsection 5 of the Immigration Act. Commonwealth citizens were protected from losing their indefinite leave status through absences from the UK until the 1st of August 1988, when Section 1.5 was repealed. This means they could not lose their indefinite leave if they spent more than 2 years outside the UK between 1st of January 1973 and 31st July 1988. All right? To give a clear example of this, Richard Black was locked out the UK in the early 80s when this Section 1, subsection 5 was still protecting his right to return without being required to obtain a returning residence visa up until 1988. I just wanted to make that clear that they were already operating the 2-year rule on people when they should not have. They're now claiming that this document is incorrect. This is their own document, by the way. And we feel that it was repealed sometime around when the Windrush scandal happened to limit the damage and fallout. Just wanted to put that on the record, and we will explore this in greater detail. Thank you.
Thank you for sharing that, Ewan.
You're welcome.
I am now going to go back and share. The reason why I'm keen to go through, even if it's just to read the topics out that's included within the 4 categories, is because these are some of the things that has been updated, and in my opinion, they're quite important to inform what you may or may not be able to do or eligible for, similar to maybe Reginald's position. Reginald, is that a legacy hand?
Is it still up? Maybe I've not put it down.
Okay, it's a legacy hand. Never mind. Thank you. So the next section from where we were, we would not be going through the columns anymore, is those who are not automatically British, but who have right of abode in the UK. This includes Commonwealth nationals with right of abode because one of their parents was born in the UK and was a citizen of the United Kingdom and colonies when they were born or adopted. So please feel free to go through at your leisure because it may be something in here within change in rules that you may be able to use to get you to where you want to go or need to be. The next heading, those who wish to prove their settled status.
Pause right there, but just go back up a little bit, please. Those who are subject to immigration control who are in the UK on settled status. Okay, go on.
Those who wish to apply for ILR, indefinite leave to remain. Here it says they lost the status by being outside the UK for more than 2 years. Bearing in mind, Anthony mentioned 5 years earlier. That 5-year rule only applies to non-Commonwealth citizens, if I may say so. More specifically, EU citizens have the 5 years. Commonwealth citizens, only 2 years, as is stated here, as highlighted. The next heading, those who wish to return to the UK from overseas. This is all within Group 1, by the way. All within Group 1, very lengthy section. Moving swiftly on. Group 2. Table for Group 2. People of any other nationality who arrived in the UK and had indefinite leave before 1st of January 1973. This is something that you and I discussed last night, and the reason why I'm saying this is because we first, or I'll pick on you in a little. You and first saw any other nationality and thought yeah, any other nationality. So therefore, Commonwealth citizens arrive in this period. But it also mentioned this was after, not before 1973. And hopefully we come on to that section. I thought this was it, where then the scheme now, the update specifies that no, it does not apply to Commonwealth nations listed in the guidance if you arrive after 1973. So that's one of the things they clarify now for the first.
So just to be clear, are you saying that the Commonwealth nations listed aren't also of any other nationality? I'm trying to understand.
Yes, that's exactly what I'm saying, and that's what we read, and I'm hoping we'll find it.
So what nationality are they? They're not any other. I don't know.
They didn't list it. So what I will do, hold on, I will go back to where they explained it better.
Also, Egbert and Egbert Lucas.
Okay, Egbert, please come in whilst I take us to the part that I would like to point. Group 1, Group 2.
Hello.
Hi, Egbert.
Me?
Yes, we can.
No,
Yes, go on.
quick question. Anthony mentioned when he spoke earlier on, he mentioned that the hostile environment 2014. Did I hear that correctly, Anthony?
Yes.
Okay. So despite the Home Office saying this kind of started with the 1996 Asylum and Immigration Act, you still feel it started in 2014?
Well, it started well before 2014 because I was threatened with deportation in 1983. And as you've just heard from Ewan, the status was supposed to be protected. So it's been going on a long time. And various laws have come into force, but the one that I'm saying created this mass of people not having documents was where it was saying that, in order to access services and to rent houses, you had to prove your status. And they brought the border into the hospital, into the bank, into the driver's license application service. So the border became everywhere and stopped people getting documents. And this is why we have the compensation scheme.
Okay, I hear that. But what about if the Home Office itself says that between 1996, 1997 and 2008, employers and landlords, etc., were obliged to, in effect, become immigration officers and check status documents. And in 2008, that's when they commenced issuing the BRP. Yeah. So I'm trying to understand, is it 1996 when this started, or prior to, or legitimately 96 or after?
So as I said, various acts came into force at various times that affected people in various ways. So where you're talking about 2008 to 1996, those would have affected people in different ways.
Okay, I understand what you're saying, but I'll tell you why I think it's very, very important, is because when the Home Office introduced the BRP, right, in 2008, what they did was anyone who was already in the UK with ILR or whatever it was, prior to that date, they were not issuing BRPs to. But anyone who came into the country, and I've met loads of them, after the introduction of the BRP were given BRP. So they went for employment, they presented their BRP, and their passport, and they got a job. But those people who were already in the country without BRP, but the vinaigrette, their passports, employers, landlords had never seen those documents before. They don't know what they are. So therefore, those people between 96 and 2008 were in limbo. They were being asked to produce a document which the Home Office wouldn't issue.
Right.
So what I'm asking, you're discounting between 96 and 2008 when the BRP commenced, and you're further discounting between 2008 and 2014.
So you must have misunderstood. So what I'm not doing is discounting. I'm saying different laws came in at different times that affected people in different ways. So it includes all of those laws, but that, you know, people would have been affected in different ways. That's what I'm saying.
And I think also,
Can I ask a question?
Okay, all right. In individual cases, Anthony, carry on, and Tanika.
Thank you for the contributions, Egbert and Anthony. June, you wanted to come in and ask a question?
Hi, yes, good afternoon, good evening, everybody. Just to go back to what the gentleman is saying about 1996 to 2000, etc. I'm a child of Liverpool, right? And Anthony, what he's saying is everything came under one, because most people had jobs. And the employers weren't looking for these things. So to be told, for some of the employers to be told, now you have to have it, was very selective. But what they did was by stealth. Because you go back to some of Liverpool and people just left because they knew their paperwork wasn't done, or they just hid and took cash in hand jobs. Right? So that was a form of discrimination. But in 2000, the hostile environment that Theresa May introduced is when it became right across Britain.
Yeah.
The one that the gentleman about to speak of was very selective. And it was selective in black areas only. Bristol, Birmingham, Manchester, you know what I mean? But the Theresa May's one, right across the board. In your face with the vans going round. So what I'm saying is, certain areas, it didn't come into effect because wasn't applicable. It was a racist law. Right? And a racist council carried it out. Some employers will tell you, we didn't know what to do. We've lost an employee. We don't want to lose an employee because we hired the person who's got a job. What are you talking about? Landlords don't want to be doing it because they're losing rent. The hostile environment wiped out everything that had gone before it. Literally. I'm not saying it didn't happen. It just wasn't in your face like a hostile environment. I mean, the hostile environment with the vans, with the posters. Who could miss that? Nobody. But Ewan, can you take on what that gentleman's saying about the 1996 to 2000? Get clarification on what the gentleman is saying, because it is important.
Yes.
Did affect black communities. Definitely. If you're just wondering why people didn't know about it, because it just wasn't nationalised, it wasn't UK, it wasn't on the BBC, it wasn't in the newspapers. So that's why some people might be vague towards that gentleman. But trust me, I can tell you.
To the 1996 Immigration and Asylum Act? Yeah.
He just mentioned 1996 to, I think, was it 1997 or 2008?
2007 and 2007 to 2014.
Hang on.
1996 Immigration and Asylum Act, UK Borders Act 2007. There's a series of legislation that came in, creeping towards what became more aggressive.
The Hostile Environment Act definitely was the one that started ball rolling right across the board. Up until then, all those little acts were very subjective. Some people had it, some people didn't.
Can I interject a minute? Yeah.
Anyway, sorry, go.
Thank you for that, June. Thank you for that, June.
Let me clarify. What I'm trying to say is, if local authorities, including East Dunbartonshire, recognise that the 1996 Asylum and Immigration Act created the effect of employers and landlords being immigration officers, we have to check your documentation. okay? Regardless of where you came from when you were born, CUKC or whatever, we have to check documentation, okay? Right, so everyone in employment who didn't hold a British passport or a European ID document, in effect, was being filtered out of the employment workforce, the housing workforce, and whatever else. All right? Okay. Now that went on from 1996 until 2008, when the Home Office commenced issuing BRP. Now you have to understand, right? Between 96 and 98, people were in limbo. You went for a job, you went for housing, etc., and you're being refused and denied. Now, the Home Office, when they introduced the BRP in 2008, they said, we are not giving BRPs to anyone in the UK with ILR or NTL. You're here, you've got vinaigrette in your passport, and that is evidence that you have a right to be here and you have the right to abode, the whole lot. But employers and landlords are asking for a BRP. They're asking for a BRP, which the Home Office isn't issuing. Now, if you came to the UK from Jamaica in 2009, they will give you a BRP. But if you were here in 2007, you can't get one.
I understand what he's saying. I think back then they were
So
still
I'm saying
just
in between
putting stickers in your passport or stamps for ILR, but the
Exactly.
new position was BRPs that were more recognizable, more acceptable, and tailored to what the Home Office was perhaps saying to accept as proof of claim. So there's a disparity happening there.
And that's the one that needs to be documented. Right, Mr. Brown saying something, the gentleman before him was something. That needs clarifying, because we could have a day on that subject. He's just mentioned East Dumbarton. I've mentioned Liverpool. Other people are going to mention other places. So I would move on to that, Anthony, and we need to go. That section alone can be a day section.
June, excuse me, can you just pause a minute? Egbert, please let June speak, and only one person at a time, so we can hear everyone. June, can you please continue?
Hi, sorry about that. Right, okay. What I'm saying is the subjects that are being discussed right now between the gentleman before Anthony, myself, and Anthony, that could take a day. You know, we could all go on about that one and the date and the clarification. I'm saying it needs more attention and more conversation. And maybe next time we have a section just on those dates and clarify what was going on in the UK. Because Anthony mentioned East Dumbarton, I've mentioned Liverpool. So I'm just saying we need to move on from that subject because it's so in depth, and we're all coming at it from different dates. You've just mentioned 67, 1977, 2008, 1996. You could go on all day giving different dates and examples. That's what I'm saying. It's not that ignore it, but we could keep going on at it.
Thank you very much for that contribution.
I was just trying to say that. It's an
just close up with something.
Egbert, hold on. Thank you. Thank you very much for that, June, again. And you're 100% correct. Egbert, please let this be the last point on this matter and very short. But before you do come back in, for Glenda's benefit, BRP is biometric residency permit. That is what people are giving now, or when they try to rectify their immigration status. It's a little card, and it gives their biometric data on there to say, well, they have a right to be in the UK. On that note, biometric residency permit is the card, the physical card will no longer be given. It will be done away with at the end of this year, 31st of December 2024. From the 1st of January 2025, if you don't register between now and the end of this year for your digital BRP card, you have to provide evidence that you've been here for a year or more when you go to register. So normally the BRP cards are given for 2.5 years. That would no longer be the case. The Guardian newspapers had released recently, a few weeks ago, that if you don't register, then you'll be faced with problems. The problems being that you'll have to provide evidence that you've been here living legally continuously for a certain period of time. They've coined this as the digital Windrush scandal, and it's estimated to affect over 200,000 people, primarily Black and Brown people in the UK. That means we have the current Windrush scandal, which we're discussing today and has broken in 2018. Now, in a couple months, a month, 2 months, we'll have the digital Windrush scandal with 200,000 people or more likely to be affected. So please, if you have a BRP card, you have applied through the Windrush scheme, which you would have gotten an NTL card, please register for the digital system, or you'll be put through this again and having to prove stuff. So I implore you, please register for the digital BRP card moving forward. Egbert?
Just a quick thing, Tanika, you got less than half an hour, yeah? Okay,
Thank you, yes. Egbert,
Okay.
please make it quick because I want to go to group 2.
Okay.
And
Very quickly. Ewan, you and Anthony, you were talking about legislation. Years ago, I discovered that, I don't know if I interpreted it correctly, but in the 1971 Immigration Act, I think it was section 33, they had already introduced this character and reasons for deportation. So I was trying to get my head around between 73 and 81 and 83, and where the BNA, where there's this, how can they have introduced something in 71 when the immigration to the UK was a lot lower from the Caribbean, and later on they're applying it so stringently. But you would have a look at it and see what you think.
Okay, I'll talk to you offline.
Yes, thank you for that, Egbert. So if just to a point, I didn't mention, just so if you need help with application to the Windrush schemes or your BRP card registration, we offer that service for free. And you can find us if you want to come in person, Liverpool John Moore University, the legal advice clinic. We book an appointment with us. We'll help you for free.
I have a question for you, Tanika.
If you're unfortunately online, we can guide you through it, but you will need to be in person. If it's easier, from my experience of doing it with clients, it's easier when you're in person. Moving on, do you want to ask a question now or after? I am also aware that there are questions in the chat that we haven't been able to address.
Just a quick question before you move off of the e-visas. This question for you, actually.
Yes.
What happens when I register for an e-visa, like the Home Office is suggesting, and I'm coming back from Mumbai, trying to get on the plane, and the system says no, the computer says no, or they can't see it because it's all digital. I no longer have this card that I used to have, putting me back in the 1973 position when people have no tangible proof of their claim. And the airline says, sorry, sir, we can't board you because we can't see your status, and we'll incur a £30,000 fine per head for you and your family if we bring you to the UK and we can't prove that you have a right to live there.
That's a very good question. My understanding of how the e-visa will work is similar to what's already in existence for European citizens with Brexit. They share a code. You log on and you get a code. And you give them and say, well, okay, here's my evidence or my right to work. Yes, e-share code. You share
but they
code.
have to use the code to see into the system, because I use the e-share code for my driver's license to show it to an employer or whoever.
Yes.
So if the system is down for whatever reason, I'm stuck in Mumbai. That's what I'm saying. It's Sunday afternoon or Saturday.
But you've just said it there, Ewan. The system is down. They will know, one, their system is down. Two, they will know that they're unable to assess your entry or exit So whatever system they will put in place of their quote unquote system being down, I can't tell you because I don't know.
But I just wanted to impress that it puts us back in that position where if I had my card, I'd be boarded. But okay, let's move on.
But that's similar to somebody being on a holiday and they've lost their passport. They don't have a physical document to travel home. What do? They go to the embassy and get emergency travel document or a letter or something proving that, yes, they are who they say they are and they have a right to enter the UK. And when they do get home, they can then apply for either a replacement passport, file a loss, and what's not.
You could go ahead and ask Richard Black how that worked out for him. But yeah, let's move on. Anthony's laughing. Let's move on. I put the proof in my hand, thank you. But yeah.
Okay. We will come to questions in the chat. Unfortunately, I don't think we'll be able to cover the compensation scheme. We haven't even completed the status, but just on the last point that I was making, group 2. And for those who joined late, we were only able to cover group 1 of the status rectification caseworker guidance schemes in part so far. Group 2, people of any other nationality who arrived in the UK and had indefinite leave before 1st of January 1973. The point I was making was that this is distinguishable against Commonwealth citizens, and it says here in the first sentence. Those in this group include people of any nationality other than those defined in this guidance as Commonwealth citizens who arrived in the UK and were settled before 1st of January 1973. So we looked earlier at Commonwealth citizens, the 65 countries that were listed, and group 2 does not apply to those countries, as it just said there. This part applies to any other nationality. Who are those nationalities you asked earlier? European Union nationalities, maybe Asian nationalities, African nationalities, whichever nationalities not listed for the purposes of the schemes as Commonwealth citizens. You were saying, Yuan?
I was saying a lot of the Asian countries are Commonwealth, so it's just strange that there's a category here for any other nationality, excluding Commonwealth citizens. I can't understand why that is. It doesn't make any sense.
It's all to do with language. We're all British-speaking territories, so they would be classified as that. You can't do something on another country's nationality, so you couldn't do it for Spain or Italy or something like that. There had to be a common denominator.
Okay, can you please explain that again, June? Because I'm a bit confused.
Sorry, when you say Commonwealth, the thing that gives them all Commonwealth is we're all British-speaking countries.
No,
somewhere along the line in the history, the British flag was over in this. So that's why any other country outside of the Commonwealth, or it includes, it's only for Commonwealth countries. It's about a law. Those countries come under British law. If that's, I can say it like that. If I go to Cuba and somebody here, there's no law. Britain had no law with Cuba. They can only look after their own. If that makes sense.
I want to agree with you, and it makes sense insofar as if it matches with this definition that they gave as Commonwealth citizens, which it doesn't. So hence I'm confused, and I'll explain that a bit further. So in the guidance here, it says Commonwealth citizens mean, for the purposes of the Windrush scheme, countries are the following. So all of these countries were not colonialized by Britain, from my understanding. Or
which country?
There's 65 countries listed here. Can you still see my screen?
Yeah, but which countries are you saying are not Commonwealth countries?
They all were.
No, they all were Commonwealth, but not.
Yes.
CUKC is not colonialized by Britain, nor do they all speak English.
Oh, no, some chose to join the Commonwealth.
Exactly, which is why they're
that's
not.
What I'm saying. Yeah. So,
okay.
I see what you're saying because I said it was a British language.
Yes, sorry. So that confused me.
Yeah. Okay. Yeah, but the word Commonwealth means it's a denomination, common denominator, I beg your pardon, either the language, the law, or you've gone through something. I think something like Cameroon is trying to join. There
Yes,
was another
here they have
French-speaking country,
some.
Cameroon. Yeah.
Yeah, here they have some who join, as you
Yeah.
said, June. Yeah.
Yes. So when I went to school, they didn't join, but afterwards, yeah, because I'm an older person. So yeah. No, but my Commonwealth is totally different because obviously some joined and things like that. But so at the time, it was British language, British law, but right now it is what is recognized as the Commonwealth.
Yes, yes.
So the country has joined, as you said, like Rwanda, Cameroon, and Mozambique, which are French-speaking territories.
Yes.
They made application to join. So that's why
Yes.
they just say Commonwealth, and they've taken out the word British-speaking, British law, and British rule.
Yeah.
I think there's another 6 that have applied to join as well.
Yes, and I think
Yeah.
there were 7 which were not colonized, like you said earlier. I think Australia, New Zealand, South Africa. I don't remember all 7 off my head, but nonetheless, thank you for that added clarity because I wasn't sure. But that just goes back to say any other country other than Commonwealth nations. Did somebody say something?
Yeah, I was saying 15 minutes remaining.
Okay, yes. So I think what I like to do, I like to pause it there and go to the questions in the chat because this here is about Q&A so that people can ask questions and get hopefully some answers. If we don't know, we will say we don't know, but we will try to find out the answers and possibly answer in the next session.
Hi. Hello. Could I just
Can I ask Herman to... One second, Christian. Can I ask Herman, who has been monitoring the chat, and thank you very much for that. Can you please identify any questions that you think need to be answered first? Because I haven't been keeping up with the chat, but we'll start with Christian because he's already on the line. Christian?
Hi. I just wanted to clarify something that you said. You said that the ILR card was given to us to basically for 2.5 years at a time, but that's actually incorrect. It's actually issued for 10 years at a time. It's only because they're changing it to e-visa that their time limit of it can't extend beyond 10 years. There's something that I think was a bit of a misinformation because you said if they don't register their e-visa by the end of December, they would have to give a whole year's worth of information to prove that they were here. But that's not actually what it is. What they have to actually do is there is a number that's like a RH or GH on the corner of their card. So anybody that's issued a card already have a number on that card. They have to use that number to apply for the e-visa. Now, what they're saying to most people who, like me, who's got an ILL, you can apply for it. You don't actually have to do any changes, providing you had a biometric card. The system will already have all your information on it. What you have to do now is, as if you want to access that information for the first time, you will need to use that number on the corner of the card. Now, I know where the year worth of information will come from. If you then go to the Home Office and say, I do not have that card and I do not have that number, they are going to ask you, like they've done with the hostile environment, to provide information. And that's where it begins to get very complicated for us. And that's where I think they need to look at the issues there, because there will be issues because some people never got their biometric card while this Windrush Compensation Scheme is running because of how slow the process has been for many people. So what you've also got to see is a lot of people may find problems just because they haven't been given their card, even though they're rightfully here. And those are the people that will experience another Windrush 2.0 on e-visas. And that's all I was going to say.
Well, thank you very much for that, Christian. And if I could go back to the first point you made, which was on the 2.5 years. So BRP cards, I believe, and thank you for correcting me, they're given for different periods because, for example, yours, you said it's for 10 years. Well, the question for me to you would be, did you get yours through the Windrush scheme? Because depending on which route of the immigration rules you follow or fall into, you get 2.5 years. Majority of the people that I know, even through the Windrush scheme, has received 2.5 years, and they have to renew it, but you don't have to pay to renew it. But in this case, you're getting no time limit, which is NTL.
Yeah, that's
So,
correct. That's correct.
so
But no time limit is given to people who have been here for a long period of time as well. So you have to understand people who had vignerets in their passports. So people who didn't get the biometric card straight away, and they may have had vignerets and they could already prove they were here. They were given their cards for 10 years simply because the 10-year motion is the same as your driving license. It wasn't 10 years you're given it for because it runs out in 10 years. You were given it for 10 years because your photograph needs to be changed every 10 years. So it was nothing to do with the time limit or who was here. Now, the people given theirs for 2.5 years, you'll find that a lot of them may have come during the year 2000, and then some of them may have come and not actually applied for a vignette one, so they didn't have a stamp to start with. So they've been given their cards, they've been given their cards for a shorter period because their period of stay will, you see, if you look at it like this, the 2.5 years, it's one of those scenarios where if you leave the country for 2 years, you know you've lost your indefinite leave to remain. But if you stay in the country for more than 5 years, you've got a right to apply for citizenship. So they've done that 2.5 years as really it's just to catch us out. It's what you're saying does make a lot of sense, because I believe that these rules and these different situations that we're all having is simply to put us all on different scales, even though most of us may have the same exact scenario. So you have to understand that, like me, who's been here literally all my life, I'm given a biometric card, but I was only given mine in 2018 when the scandal broke, even though I was eligible for it from the moment it came out. But they still only gave me mine for 10 years, then suddenly visa. So mine's only lasted 6 years, but it still runs out in December. But like I said,
yes,
a lot of
yeah,
people will be given that the card that they've got, they should keep, even if it expires, they should still keep the old card, because the number on that card does not change for each person. It's the same number you get from the beginning to the end. So it's that number that's important for the e-visa. And that's what I was trying to emphasize. A lot of people may not know it, but that little RH number on the corner is actually your lifeline, because without it, they will give you so much problems telling you they can't find you on the system because you don't have that number. And that's what they don't tell us from the Home Office. And I got that information from the Home Office, where they had to highlight the fact that if you look at the small print on when you get your biometric, there's actually a small print on the letter that comes with it that says, do not lose this letter. It contains the number. And if you lose your card and this letter, we may have difficulties finding your status. So it's already told to you, but it's so small you can hardly, you wouldn't even catch it. The way they worded it and the way they put it, you'd think, oh no, it should be easy for them to find me now. That's not the case.
He's absolutely right.
So a lot of people have to be aware. Just make sure you know what your RH numbers are, your IOL numbers are, your NTL numbers, your every biometric number they give you. You'll notice it's the same for your individual number, but they put them in different places. On the card, it's in the corner. On your letter, it's in the it's actually written in the section where it says how you are. On the e-visa, the number's not even there. It's turned into letters instead of numbers. So you've got to be well aware of these things, and they are going to try and catch us out. So I think everybody, this is the best thing you're doing, highlighting it now, because they're going to try and catch us out. That's the truth.
thank you very much for that, Christian. And
All
just going back to the next point that you raised with regards to the evidence that people will have to show from the 1st of January 2025, where I got the information from was publicly available sources. More specifically, the first time I'd been alerted to it was from the Guardian News. And what you said is news to me today. I had not read it anywhere. And I have done and had done research on e-visa and everything that I could find. So thank you very much for sharing. But nonetheless, please be aware it's much easier now to simply register for it than waiting until the period has passed where you have to produce the share code and you don't have it because you didn't register in advance. And then you may be made to show evidence. So that is what I was imploring people to do. But thank you very much for your contribution, Christian. Yuan?
Can I just add, Leonie? Sorry.
Thank
that.
you, Glenda. I'm not Leonie.
Oh, sorry. Sorry. Sorry.
5 minutes left, Tanika.
Oh, yeah. Thank you
Herman's
very
still
much, Herman.
waiting. I'm waiting still after you finish with Glenda. I know
Yes.
Glenda's question on the biometric card, I think. Yeah.
Okay, thank you, Herman. Glenda?
Hello. Yeah.
I just wanted to say that e-visa, and I agree in part with Christian, you have to do that e-visa. But remember, it's for the authorities, in a sense, to check your status. You're registering and updating your status through this e-visa scheme. And it is it's not as easy as it sounds, because even when you apply or register for the e-visa, it's a process. It's taking time. A lot of people are having difficulty even now because they're being notified to change it to the e-visa. So a lot of people are going to need help. And the other thing as well is, even if you've got a biometric card and you've got a passport, you still have to do an e-visa, especially if you're traveling. Yeah, that's just what I wanted to say.
Thank you very much for that contribution, Glenda. Herman?
Just, I know in the questions in the chat, you've got Adi and Augustine. I know they just need some help with regard to those, the BRR cards, yeah?
Yes.
So you could give them the details with regard to that.
No.
And I know I think Jane Lewis has got her hand up. I know she's offered as well to discuss things if people wish to discuss some of the things which happened today. I know she's based here in London, like myself. Yeah. So that's all really. They're the ones which stood out. I know Neil's got a number of points he's actually made as well. So that's all I can say for that. Yeah. Okay.
Thank you. Neil, do you want, sorry, you said June has her hand up. June, do you want to come online? Or
no,
not, Neil?
I'm good. I'm just asking people if they can put it in the chat or send it to my email, because so many good points have been here. You know, I'm writing them down crazy. But thank you for everybody, because yeah, it's a bit of a wake-up call. I'd forgotten about that e-visa thing.
No problem. It's being recorded, so we can send you the recording after. We'll put it also on our YouTube channel, so you can also go back and listen.
That would help. Yeah, thank you. That's great.
You're welcome, June. Neil, do you want to come online and hopefully we can try to answer some of your questions?
Yeah, I'm okay. I can refer to the questions. There may be some background noise. That's why I'm writing in questions.
I think Jane's hand is still up. June's hand is still up. I mean.
Okay.
That's a historic hand. Just take it down. I've asked my questions. Thank you.
Okay, so Neil, you're welcome to. We can see how we get on with the noise. Alternative to that, Herman, can you please read up? Well, see if I can find the most pertinent.
Okay, so some of the questions I have, I hope it's clear enough to hear me.
Yes.
For example, the most recent one, I'm making an observation that Commonwealth citizens pre-1971, some of them were issued ILR, some of them were not issued ILR up until 1977. For example, two parents, one parent received ILR stamped on the Commonwealth passport, one parent came and left several times, no ILR up until he left in 1977. Observation, ILR ID was not consistently issued for pre-1971 citizens. So that the question is raised, why is that discrepancy there? Is it because of right of abode, or is it a lapse in the British Home Office in issuing ILR ID to citizens who are getting it and not getting it? It's very confusing about the complexity of the whole settled status and right of abode. My next question, this is the last question, is what category does a British-born citizen by birth not needing to naturalize to Commonwealth citizens who never held British nationality, other than being post-colonial nations of a British colony? What category of nationality would that person hold? He was a British-born citizen by birth, no need for nationalization, but his parents were Commonwealth citizens of post-colonial country, never held a British nationality other than when they were ruled under the British as British subjects. Those are my two questions.
I'm sorry, I didn't hear the first question clearly. I heard the second, and I can answer the second UN if you want, but please feel free to answer
I didn't
both.
hear the second one. I didn't hear the second one properly.
I heard the second one properly. I didn't hear the first one properly. So do you want to answer the first and I answer the second?
Okay. So
And
you were
just
asking
before
about the
you do,
consistency between ILR and ILE going back into
UN,
the 70s. Yes. Can you
excuse
hear
me,
me?
can you just hold a minute? It's just 1 minute after 5, everyone. We do appreciate that the session has now officially supposed to end, but because we can stay on if we want and we choose to stay on, please feel free if you have to go. We understand, but thank you for your contributions today. We are going to stay on and engage with the questions. Again, please feel free if you have to go. If not, please stay and we'll continue. UN, thank you.
You're welcome. Thanks. The question of consistency across the board in the 70s, I believe, with issues, I think some of the issues were like people getting different stamps at the airport when they arrived or came back, and I saw that same inconsistency you're talking about, and it's kind of hard to determine what the author was thinking. It may very well be down to lack of understanding. The Immigration Act, when it came into force, whether immigration officers were properly trained. And I say the Immigration Act, but not necessarily the 71 Act, the 62 and 68 Act. Some of them were hastily thrusted upon the public, and immigration officers weren't properly trained. There weren't a lot of immigration officers. I think there was just not real consistencies. And then there became some more consistency and even more confusion. So it's kind of hard to determine by looking at an old passport what the author was thinking when they stamped you, you know? So I think that's also my experience of looking at different passports as well.
Neil, does that answer the question?
It partly does. I have some information from a Home Office representative stating that different stamps have different meanings. Different stamps
Yes.
have different meanings, and deciphering that is very complex because we do not have that knowledge.
We can probably try to answer that on the next session, but you're right, it did have different meanings. For example, from triangular to, say, for example, rectangular to circle, they did have different meanings to indicate
Triangles were
different things.
exit, right? I think those were exit stamps.
Even entry, they have different meanings. What that's what I am aware of. So you are right, Neil. But
What
I
was
don't
the
know what they all mean. With regard to the second question, and if I remember the question correctly, is Commonwealth citizens who were here give birth to a child here. The child never had a passport, and I presume never registered as British, and never had what rights do they have? Basically, is what you're
Correction,
asking.
I did have a passport in 1981. The question I'm raising is what category is British nationality did I acquire when my both parents were Commonwealth citizens? What category of British nationality did I acquire to Commonwealth citizens pre-1971 Act?
Okay, so
Something weird there.
sorry, what you say, Yuan?
Something was going inaudible. I couldn't understand exactly what he said.
Basically, if I understood correctly, that his parents were Commonwealth citizens. He was born, I think, 1971. What would his status be? Would he be
In the
British or
UK,
would he be in the UK? Would he
I
be?
know my status. I'm trying to find out what category of British nationality did that fall under, because I saw the listing of who is
Oh,
entitled to right
okay.
of abode. What category did I fall under? As a British-born citizen, I confirm I'm a British-born citizen by birth.
oh,
To two Commonwealth citizens, what category did that fall under?
yeah, so it wouldn't have mattered so much about your parents unless your father was a diplomat or an enemy alien. Once you were born in the UK before 1983, you were full citizen, and you would have had right of abode under Section 21A, born, registered, or naturalized, or adopted in the UK. That answers your question.
Surely they've categorized that in relation to common citizens giving birth to British citizen. They should have they have that categorized somewhere in the Windrush claims.
Oh, you're talking about okay. So I think it's in there on the pre-1973 arrivals. So your parents arrived pre-1973, and then you were born here. Is that sort of what you're asking, right?
Yes.
Yeah, I'd have to check the tables again because I see what you mean. I know they talk about, I think they do have a category for that. I can't remember off the top of my head. I'll have to look
They
at the
must
chart.
have, because I am British by birth. I
Yeah,
just don't
there's
need to nationalize.
So if I was to try to answer that question for you, Neil, it will determine on what, even though your parents were Commonwealth, what were their status? Did they have settled status or not? Even though you were born here to Commonwealth citizens, you would have adopted their nationality. Even though you're born in the UK, you do not get British nationality by birth. No, it doesn't work.
No.
It will depend on if his parents had settled status that they can either pass on their settled status or national.
Not then.
No, not then. It's only after
Not then.
83. He's talking about what category he falls under in the Windrush grouping, the groups. So parents arrived pre-1973, child born in the UK, over to eligibility. That's what he's talking about, not what birth status or nationality status.
So for example, I could ask the same question. I was born in 1963. My parents.
You're British.
Yes, but my parents came from a country that had independence in the 70s, I think, because they came from Dominica. So I'm British. I'm classed as British.
But did you take your status from your parents or from the place of your birth?
Well, that would be the question. It's
That's
not
the
in question.
It doesn't matter.
But Neil's asking the question in relation.
Yeah, Neil's asking that question as far as I understand.
Yeah.
Yes, I'm asking, did I get the status, British nationality status, on my own right or my parents' rights?
Your own right. Your own right. Any person born in the UK before 1983, which is where rights of the soil changed in 1983 to rights of blood. So you're born on
Say that again. Sorry, Ewan.
When Margaret Thatcher introduced the British Nationality Act 1981, it was designed to change rights of soil, birthrights of the soil, to birthright of blood. So that's why if you're born in the UK after 83, your parents must either be settled or British. If you were born before 83, the only thing that matters, you will be British unless your father was a diplomat or an enemy alien. I think that still applied to some degree.
Okay, is that okay? Sorry.
Enemy alien.
Yeah. Right. 1983 was right of the soil, meaning you had the right because you were born on British territory.
Before 1983. Before 1983.
Yeah, before 1983, it was right of soil. After 1983, it was the right of the blood, meaning the right of your parents. Because that's the one that some people are disputing because they've been rejected. Because even though they were born here, their parents, it was about blood more than being on the soil.
Yes,
and if the parents didn't have it, or if one child, and this is what people have to remember as well, if one child or one parent should be, if the child was illegitimate, that was what I was trying to find out.
Yeah, I was going to ask about that.
Yeah. Does the child take the right of the father or the right of the mother? Meaning, yeah.
Good question, June. Good question.
Yeah. They set up house here, they had the child, and they're from different places. Yes, does the child take the right of the father or the right of the mother? The question was answered because you took the right of your father. In this country, you take the right of your father.
Before 83.
That's what I was told, and I need to clarify that.
Yeah, so June, again, with that,
Sorry, I need to clarify that.
there's differing degrees. So before 83, the nationality status apparently flowed through the father. Only in certain exceptional circumstances did a mother could possibly pass on citizenship outside the UK. So on the soil didn't really matter who your mother or father was, only unless he was an alien. After 83, it then transferred to the mother, and the father had to be married. So after 83, your mother could transmit it on her own if she's British, right? But if the father was transmitting, if the father alone was British and the mother was foreign, then they would have to be married. Legitimacy came into play in order for the citizenship to flow. Okay?
So it's about the maternal line in 83. Prior to 83, it was the paternal line. Is that correct?
Yes.
Yes.
Yeah.
Yes.
Okay. I've got that.
And to answer Neil's question, I think this is why we were going to the groupings. It explains now a bit much more clearly, in my opinion, of questions like Neil's. So Neil's question was Commonwealth citizens.
Group 1 or 2, yes.
Sorry?
He's either group 1 or group 2.
Yeah, so that's why I went back to the groupings, to at least we have a visual and we can hopefully provide a clear answer based on the schemes as is today. Citizens who arrived in the UK. Go ahead.
Could I ask a question? Sorry about that.
Of course, yes, please.
I was born in 1965. My brother was born in 64 in UK. My parents came from Nigeria to come and work in the UK. But my dad obviously more or less disappeared from the family, still married to my mom. We don't know if dad is still alive, but the pensions department will have details regarding my dad. So there's a possibility that our dad is now British. But my mom, I've been struggling being the main carer to help my mom with her Windrush. The first application was submitted back in 2000, 4 years ago, and the last one was submitted this year. And she's done her biometrics on the 7th of September, and we're still waiting. We don't know what is happening.
Can we speak offline, Ade?
Okay.
If there's a specific question that you want to ask that will benefit the audience, yes, please feel free and we can try to answer that. But specific personal data, we prefer to deal with offline, GDPR and privacy.
Oh, okay. Thank you.
Can I just ask, where were you born? You say you came here in 64.
My mom came 62, but I was born in 65.
Here in the UK?
Yes. I've got British.
Then if I'm right, Ewan, isn't she right, born of the soil?
Yeah, that's the soil.
Right. So long as her father was not a diplomat.
No, he wasn't a diplomat when he came.
Okay, so then you're British. What was your nationality of your mother? They were British?
I don't know, but I know she's using Nigerian passport.
Okay, you need to find out the status of your mum.
Did you say in 62?
She's born 62, so she's pre-1983. She takes the father's side. She's paternal.
No, June. June, I think she said they came to join the father. The mother came in 62. Ade was born in 64.
No, that's what she's not saying that. That's why I asked the question.
Ade,
my dad, I don't know when my dad came, but my mom joined my dad too. They got married in UK. My senior brother was born in 64 and I was born in 65. Both my brother and myself, we got British passports. But like I said, I don't know the whereabouts of our dad. But the pensions people have information about him. We've been trying to get information about him. He knows a lot of things happening, but we don't.
Right, so but I'm saying, I'm just saying, if I go back to what Ewan said about 1983, we took the paternal side. You said your mum came, she married your dad. Your dad was British, correct?
We really don't know because, like I said, I was very young.
So you don't know your dad's status?
I don't know his status. That's the problem.
Okay.
Richard has his hand up. Reginald, I mean.
Yeah, Reginald. Neil, we will come back to your question. We're just trying to find. I'm trying to find the appropriate subsection and which grouping applies. Reginald, you're on mute. You have to unmute if it's no mistake.
Can you hear me now?
Yes.
Hello?
Yes.
So prior to 1983, you can only transfer citizenship by father, by the male line, irrespective. So in Ade's case, if her dad came here and settled, would have been a CUKC, like my dad. Would have been a CUKC, right, with the right of abode, which we automatically transcend in 1981 to be a full automatic citizen. So in 1965, Ade would have got her citizenship from her dad, not from her mom.
We can't determine that conclusively because we don't know when he arrived. And did you say
That's
Nigeria?
what she's saying. Yeah, that's what she's saying.
I'm Nigerian.
UN,
Yeah,
hold
I'm
on.
Nigerian.
Please let him finish. UN and June, please let him finish.
So I'm Nigeria. It's a similar case, right? You cannot transfer citizenship on the female line prior to 1981, right? So even if the mom was a citizen, she would have to be married to the dad, isn't it?
No.
No. I think we're getting this a little bit confused here. Let me clarify. Allow me to clarify.
Okay,
you clarify.
So let me
what I'm
clarify.
trying to say is that okay.
We're talking about two different things. So if the child was born outside of the UK, then it goes down the male line. If the child was born inside the UK, doesn't matter anything about the parents because they have the rights of the soil in their own right. That's the difference right there. The point
but they have to be settled.
Yeah, no, settled is
they have to be settled
83.
No.
You didn't have to be settled before 83. Never an issue.
Pre-83.
So what I was getting at just now when I was trying to stop you is she doesn't know exactly when her parents came. So she would not know the status they had when they came because Nigeria became independent in 1960. So if they arrived in 61, they arrived not as CUKCs, but as Nigerians. So that's why I didn't want to go into it. And I think that's why
my dad arrived 61 and he was a CUKC.
Yeah, but he registered, right?
He registered, yeah.
Right. So that's why we're not trying to deal with it like this. You see?
Right. It's a different case.
Yeah.
Sorry to interrupt. Sorry about that. It's a different case. So I get what you're saying, and Ade will speak to you.
I get it now.
Yes, thank you.
Welcome.
Thank you.
Thank you all. This is the fun part, in my opinion, of the Q&A session, to brainstorm instead of it just being one person and share information. So thank you very much for that. Going back to Neil's query in question, you
there?
I'm still trying to find which
I know it's typical. I think you might want to deal with that offline, to be fair.
Yes, I think so, because I'm trying to find which part of the section actually applies to the facts that he is given.
It's likely group 2. If you were to do a search on your Control F in the group 2, you might find it easier.
Okay, so group 2. This is group 2, and we're in now. But
it could be group 1. I would deal with it offline. It's there.
Yes, Neil.
I would deal with it offline because it's so much data.
Yes. So Neil can between you and I we'll contact you. We'll deal with it offline.
That's fine.
I think that will be.
That's okay.
You're welcome. Is there any other questions you had, Neil? Because I know you did put a few in the chat. But
the reason why I asked these questions was it has implications for a lot of British-born citizens and their parents. It has a lot of implications. So it's not just about me; it's about so many other citizens from the Commonwealth, from the UKC, who may have got entangled.
Okay.
Agreed.
Can you go to Augustine? I believe there was something with regard to the biometric card.
Thank you, Herman.
Augustine. Is Augustine still online? I believe he is. Augustine.
Augustine, do you want to come online and ask? Egbert, I saw your hand up before. We will come to you next. Augustine?
You need
Please
the rest from
unmute.
Egbert.
Unmute.
Hi. No, I was just inquiring on how do you register? What's the website, etc., etc.
I did post a message to that, Augustine. I put a link to the website. You check on there and it'll say start register and you just follow through. But I
Okay.
can give you an idea of what you will need. So you'll need a smartphone, you'll need a laptop because you'll have to do things on your phone. You'll need to download an app, you'll need to take a selfie of yourself, and
Really?
it may make you do the same thing about 3 times and you'll think you're running mad. It made me feel that way every single time I did it for someone. I'm like, really? But please stick with it. You, and why are you laughing?
I'm laughing because everything that deals with immigration drives you mad. It's almost like it's a deterrent. Believe me, I tell you.
But
probably is.
Augustine, please stick with it on a serious note, and eventually you'll come to the end and it'll say, yes, you've now successfully registered.
It's almost
Right.
it's almost 4:30 now. So Egbert, don't go on forever, please.
Yeah. So can I just wait though, because I have a decision awaiting.
I would suggest that you don't wait. It won't take much out of you, hopefully not more than an hour to do. But even irrespective of which way your decision goes, you would have done it. Does that make sense?
Yeah. It
Because
does.
then you have to possibly prove things after the 31st of December 2024. If you wait, it'll just save you a lot of headache later on. God forbid.
Right.
So that's just my personal opinion
Okay.
on that.
Can I make just an interjection there? To anybody who's thinking of waiting, please don't. Don't give them any more ammunition, because if you wait now, I guarantee something will happen and it was woulda, shoulda, done it, could have, didn't. Life just catches up. We're in November.
Okay.
Yes.
Right? We've just got, we've just had our voting results. There's things going on in America. Just register what you can. At least you would have a reference number. At least you'd be in the system.
Yes.
I don't know what the Tories are going to do. I'm looking on the pessimistic side, and I speak to some people and I'm like, don't delay what you can do today.
True.
All right then.
Thank you very much for that, June. Unfortunately, no, it is true. It is true, because why are we even here doing this? Why do we have to? So please don't. I echo the sentiments, June.
So would you say that everybody should apply?
Those who have a BRP card.
Only if you've got a biometric card. Because I know on there, if you've got a passport, you can register for an e-visa.
Why would you do that? No.
No, if you to register, and when you set up your UK VI, because you've got to set up your UK VI first.
So not if you have a British passport. If you have a foreign passport with right, for example, you're a European citizen and you have a foreign passport, then you have to register, because you may not have a BRP card, but no, not passport. Sorry, that's something else I did for someone else.
Yeah, that's something totally different.
Yeah,
I'm just saying to people, these cards, everybody will tell you somewhere along the line, you're going to need some kind of identification, outside of a blood test before you can apply for anything. You watch what they start asking for, and it's frightening. And I always say to people, what do you think is going to happen if you don't have it? Why are you giving them ammunition to even question you? You don't drive a car without a driving license. If they say you need this visa, don't even question it. Don't take an attitude. Don't think about it. Just put yourself in the system. You live in the UK. It's one of the questions asked. And this e-visa is neutral.
But
do you know what I mean? It's right across the board. It's like your driving license. It's right across the board. You have your driving license. That counts as a legally recognized government issued documentation. And most of the time, that's what these people are asking for. We've just said, I do think the Home Office got trained at different levels. Immigration officers got trained at different levels. It was left up to the person. You know, there was no standard training. I don't think so, because I'm sure October's spoken. No, sorry. Anyway, that's what I'm saying. Just do it where you can. Thank you.
Thank you very much for that. Egbert?
Yeah, hi.
Hi.
Following on from what June said, and I'm going to be very quick, Herman. Looking at the e-visas and all that kind of stuff, if we want to avoid these problems, why is it that people who are applying for the scheme just don't apply for British citizenship and passports?
I can answer that question, Egbert, because they can't. There's reasons why. So, for example, we have a client. I have a client. We have a client, and lived there majority of his life, but maybe for say 10 years out of 50, 60 years, and went through the schemes, received indefinite leave to remain NTL status, but was refused British nationality.
Like Christian, yeah.
So not because they don't want to have British nationality or for lack of trying, because they can't.
Yeah, but what I'm trying to say is, if we were to go through the process of everyone who's an applicant or a sufferer or victim, whatever you want to call them, go through the process of applying, and then we filter out the reasons why they're being refused, then it would solve a lot of problems. It would actually deter problems on the line. I mean, I'm a dual national. I'm Guyanese. I'm British now. Okay, and I don't really want to be going down that route, but I know a lot of people who have come up to this country many years ago, and they still can't get a British citizenship for many reasons. But they're
Can
not.
I answer that one? Sorry. Sorry.
Yes,
Can I answer that one? I remember
yes.
years ago. Yeah, years ago, going back to what the gentleman from who's just said about Guyana. My friends who were from Trinidad and Barbados could not have dual nationality. At one time, you had to choose one or the other. It was about owning land.
Yep.
So if you wanted to keep your land in Barbados and Trinidad, as far as I can remember what they were saying to me, you never apply for full British citizenship. So when these acts came in, they chose where their passport should be, but still had cars that let them come and go on holiday. It's only when they were thinking of going back and settling and things like that, these questions came up. And I was like, shoulda, woulda, coulda. Why didn't you do it when you had the chance? Like you said, why didn't they do it? It's because it was landed. I'm just giving you an example. When you say it was one of the reasons that some people didn't, because I think at the time your government didn't allow you to have dual nationality.
Yeah, but there's also another aspect to it. What the British government were looking for, like people like myself, who'd been in this country, like Anthony, I think, mentioned this years ago, was commitment. Do you commit to being with us or not? I mean, I'd been here since 73, and I was told, even Margaret Thatcher changed the legislation, that you don't need a British passport. Your Guyanese passport and the ILR NTL status is as good as British citizenship. But at some point, that wasn't satisfactory. So my still question is, if people are going through the stage of applying and put it to the scheme, if you apply also for a British citizenship, and then you filter out the reasons why they're saying you can't have it, and then compile those and go forward, rather than walking into the situation of an e-visa, etc., etc.
Oh yeah, no, I would say the e-visa is the last choice. Go through all the other issues first. Like you just said, if there's a list, then there's a list, and there's something you can tick off the list and apply for, then do that. But if e-visa is the only thing you can do, then do it.
Okay.
At least you have something in motion.
Okay, I'm gone. All right, thanks.
Thank you for that, Egbert. Thank you for that, June.
Thank you, Egbert. Thank you. Bye. I'm still on.
Yeah. Herman, is there anything else that we need to cover before we conclude? Herman?
Not that I could see. Egbert's hand is still up. Let's see.
Okay, that might be a legacy hand.
No, Neil's made a
all.
few points. Neil's made a few points. So that's about it, really. Yeah. Everyone else is just hanging on because we're just being nosy, really, listening to what's going on. So, yeah. Yeah. So that's about it, really. Yeah.
He's calling me nosy.
Can I ask you? Can I ask you and Ade a question?
Okay.
Before you do, June, hold on. Dave, do you have a question?
No, I don't have a question. I just wanted to say thank you. That's the first time I've listened to this, and it sounded like the old free talk on a Tuesday night. It's very interesting. I've learned a lot myself, actually, tonight.
Thank you, David. Thank you, David.
All right.
Thank you. Yes, June and Yuan. June, you wanted to ask Yuan a question? Thank you, Herman.
Yeah, hi. Herman, thank you very much for being a great moderator. Ade and yourself. If there was one thing, because, you know, me and you get triggered, because we were at the beginning of this whole Windrush immigration, migration, and not too sure what's going on, that you would tell people now to do for themselves. The one thing I would say is get your paperwork in order. Don't wait for them to ask you for this piece of paper and that piece of paper. Because I keep saying to people, how come you don't know what school you went to, what job you had? It's there in black and white. Go online. People can send me an email. I'm happy to meet with them. Herman, I might ask you, we meet in London somewhere. We'll go through with you. We'll set you up online. We'll set you up an account. The most triggering thing you can have is a conversation with some of these officials. I'm not going to go into it, but I know compliance. And some of them can ask questions how they want, why they want it. It was the same with the passport. You got your triangle, you got your circle, you got your square. You don't know whether it was right or wrong until you went on another trip and then somebody told you about your passport. So I'm just pleading with people, those of us that are looking after community groups, ask the question. Do not feel bad about asking a question. No question is silly, stupid, or wrong. Just keep that in mind. This is one of the elders here. Yeah, I've been through it so many times, and I'm telling you, you have to face certain things in this country as a Black person.
Thank you very much for that, June. Yuan, do you have any retort before I summarize and bring us to a close?
No, I don't have anything to add, unfortunately.
Yeah.
Okay, thank you. In conclusion.
Oh, wait, did you say summarize? As in
yes,
wrap
I'll
up?
summarize what we've done today, just bullet points.
Respond to June, right. So, just briefly, we covered some of the information within the Windrush status documentation scheme. It's not clearly labeled that way. I think it's just called the Windrush scheme caseworker guidance, but it deals with documentation. We covered right of abode, some of the disparities contained within it, how people are British by descent or otherwise than by descent, and how it impacted them in differing ways. We also looked at the fact that Commonwealth citizens can have a right of abode without being a British citizen, etc. And we also looked at some of the changes in the latest version of this document, not in a great degree as we had hoped to do because of the time constraints within the period when we got the document and presenting the show today. But we will look at that in greater detail at some point. And I just want to say thank you, everybody, for coming. And thank you for sharing your views and asking your questions. Thank you.
Thank you for that, Yuan.
Just before you go, did you share that other document? Oh God,
I didn't because I don't have it by link, and I don't know that. I cannot touch it here. Can I?
You can. Did you say?
He will try to, Glenda, or if not,
I've got your email, Ewan.
Yeah, pass it on.
Okay, so in conclusion, thank you for joining us today. We were meant to look at the Windrush Compensation Scheme criteria along with the status scheme criteria, we were unable to do the compensation. What we have done, as Ewan said, we did look at the Windrush Scheme Caseworker Guidance version 8, which was released on Friday, the 1st of November. We went through some of the changes, which is enumerated on page 6, what the changes are, and then specifically at some of the Windrush groups, eligibility and criteria. We tried to work out the nuances, but we were unable to complete. If any of the information we've discussed today affects you or you're curious and want to know more, reach out to us. You can find more information either through our website or how to contact us at liverpooladvocatesforwindrush.org, or you can visit us at Legal Advice Centre, Liverpool John Moore University in Liverpool, or give us a call. Our next monthly session is the first Sunday of every month, will be December, the first Sunday of December. We'll share information in advance of that session. But thank you. We have gone 36 minutes over. Apologies, but I also enjoyed it. So I am grateful to everyone who attended. Thank you very much for your contributions. If anyone has any questions before we go, any queries or comments, please share our information with anyone you know that it may be beneficial to. The video will be on our YouTube link, Liverpool Advocates for Windrush. And if there's anything that we missed, anything that you think we should have covered, have any questions, please send them in advance before our next session. Otherwise than that, thank you very much again and have a blessed evening and a great week ahead.
High fives to everybody. Awesome. Awesome meeting. Well done, Ewan. Well done to Liverpool. Herman, yeah, fantastic. To everybody who asked a question, yeah, it was all information. It's, yeah, brought back some memories, but every question was relevant. And
Well
also
done.
the questions were needed. They were needed to be asked. Thank you all. Bye.
Thank you, June. Thank you,
Bye.
Glenda. Herman, thank you again.
Good night,
Yeah,
Tanika.
good night, Glenda. Thank you for getting my name right, honey.
Of course, of course. I don't know why I said that. Yeah, I even wrote it in the chat. But
Thank
well
you,
done.
Andy. Thank you.
Listen,
Right.
you've got. I'm sorry I've missed them all.
That's
Yeah.
fine.
So,
But see you all soon, yeah? Well done.
take care. Bye.
Thank you. Bye, Dave. Bye, Herman.
Bye, everybody. Bye, Herman. Bye, Ewan.
Bye, everybody.
Bye.
Tanika,
Dave.
Ewan, are we going to stay on just for a little chat after?
Yeah, we
Bye.
can do.
I'm gonna-
Okay.
We'll stop the
Bye.
recording.
Bye,
Thank you.
everyone.
Bye.